My apologies. Okay, I think we're good to go now. Does that look good for everybody? Okay, good evening and welcome to the new fight for voting rights, COVID law post-2020. Tonight we'll hear from two incredible panelists, Julie Ebenstein, Senior Staff Attorney at the ACLU Voting Rights Project, and Jim Blacksher, longtime Alabama-based voting rights attorney, on what's happening in voting rights and election law post-2020 and what we can expect moving forward. My name is Sam Reese, and I, along with my fellow Andrew Goodman Foundation ambassadors Meredith Saylor, Ali Swan, and Jack Kappelman, will be moderating tonight's discussion. Before we begin, I'd like to thank the Blackburn Institute, the Crossroads Civic Engagement Center, and the Graduate Student Association for their support in organizing and promoting this event. And I'd like to invite our audience to submit their own questions for our panelists in the YouTube chat. We'll be keeping an eye on that and trying to get as many of those questions in as possible. So without further ado, I'd like to introduce our panelists. Julie Ebenstein is a senior staff attorney with the ACLU Voting Rights Project. Since 2013, she has litigated voting rights matters across the country, including challenges to felony disenfranchisements in Florida and Iowa, discriminatory voter suppression laws in North Carolina, at-large school board elections in Ferguson, Missouri, dual voter registration systems in Kansas, and election officials' rejection of absentee ballots based on voter signatures in California and in New Hampshire. Leading up to the 2012 general election, Julie was a staff attorney with the ACLU of Florida and counsel in several voting rights cases. She's written and testified on the detrimental effect of criminal disenfranchisement laws and the intersection of overcriminalization, prison gerrymandering, and voting rights dilution. Before joining the ACLU, Julie focused on refugee protection issues, working first with the International Rescue Committee on the Thailand-Myanmar border, then with Lawyers for Human Rights in South Africa. Julie is a graduate of Columbia University and Fordham University School of Law, and she's admitted to practice in New York and Florida. Jim Blacksher is a native of Mobile, who after 6 years in the US Navy, graduated from UA Law School and began practicing law in 1971 when he joined Vernon Z. Crawford's law firm in Mobile. He moved to Birmingham in 1988. Mr. Blacksher served as a counsel in numerous voting rights cases, including Bolden v. City of Mobile, Dillard v. Crenshaw County, and Alabama Legislative Black Caucus versus Alabama. He has represented Black voters in every post-decennial census redistricting of the Alabama legislature since 1980. He was also plaintiff's counsel in the Alabama higher education desegregation case, Knight Sims v. Alabama, and is currently one of the lawyers representing plaintiffs in Thompson v. Merrill, which challenges Alabama's discriminatory system of disenfranchising citizens who have been convicted of a felony involving moral turpitude. So to start us off, Ms. Ebenstein, could you tell us a little bit about your work, both generally and over the last year, and the highlights of what you saw changing or maybe what you didn't see changing in election law and voting rights in 2020?
Sure, and thank you all for having me. Thanks to folks who are online for joining us this evening. I'm Julie Ebenstein. I work for the ACLU Voting Rights Project. We litigate voting rights cases throughout the country in a number of different states. And in the past year, we obviously had a very active year trying to protect the right to vote. So maybe I will just very, very briefly go through some of the background that got us to 2020, the unique circumstances of 2020, and what we might expect going forward. So the history of voting rights in 3 minutes or less. I think two things that are important to keep in mind when you think through voting rights are, number one, there's often going to be a legislative self-interest. Meaning that at the state level, legislators have an interest in containing the right to vote to those folks in that system that elected them, right? They were elected under one system. As the electorate and the voting public changes, there's a lot of unknowns, whereas they know that the prior system elected them personally. So there's always some self-interest of legislators, and in particular state legislators, to keep things as is or to guard against an unpredictable expansion of the electorate. The other thing to keep in mind about voting rights is that it's a shared federal and state authority, meaning that states can control or set the time, place, and manner of elections, and Congress can also alter those regulations. It's a shared power, and that in some ways causes a lot of tension. We use a lot of federal laws and constitutional rights to try to challenge what we consider voter suppression efforts, oftentimes in federal court. And the laws or the regulations that we challenge are often state laws. Elections in the US are very localized. So the details of any law that affects voting rights, it's always interesting to look at how that will play out on the ground and who will have more or less access to vote. The other thing to think through as far as the history of voting rights is the trajectory that things have taken. So we saw in 2008 the broadest expansion of the electorate that we've seen in a long time, both in terms of turnout, a very young electorate, and a very racially diverse electorate. Following that election, there was really a swing in the other direction among states to try to restrict the right to vote. And on the heels of a Supreme Court decision in 2013 called Shelby County, the protection for voting rights at in federal courts and through federal law was much more limited. So we really saw a push, in my view, to try to restrict the right to vote without the same protections that we had for voting rights previously. Where did that leave us in 2020? That's a bit of a summary of the law. We obviously had an extremely unique election this past year. I know that from what you all have told me that you're back in class and in person, but of course in November, nobody knew what, leading up to November and then for the election itself, nobody knew what was going to happen. We had this pandemic that obviously affected everybody's day-to-day life, and certainly the administration of what is often a primarily in-person event, which is an election. So we saw litigation to challenge, among other things, some of the issues related to how the normal administration of the election would be impacted by the pandemic. For example, in many states, people need an excuse or a reason to vote by mail. Here we had a pandemic where pretty much everybody, or certainly many people, felt much safer voting by mail. And my organization and many others challenged some of the states that required a disability or another excuse beyond just the pandemic to vote by mail to try to expand that sort of access. Similarly, there's petition signature requirements to get people on the ballot or to get propositions on the ballot. Of course, you have to go in person in normal times to gather somebody's signature, and that was exactly what the CDC and others were recommending people don't do. There were similar notary or witness requirements for vote by mail ballots. There were ballot receipt deadlines that we challenged because of the slowdown within the US mail. There were a number of provisions that under normal times might not limit people's access, but during the pandemic did. And I use those examples both to discuss the 2020 election, but also to say that there are a few laws that are inherently all the time suppressive or discriminatory. It's how laws play out on the ground. Requiring an excuse to vote by mail might not have a hugely detrimental effect when there's not a global pandemic. But we saw when there was a pandemic, people wouldn't be able to exercise their right to vote if we required a narrow category of excuses in order for them to use vote by mail. So that's important. We have to think through not just what these laws say, but how they're going to play out on the ground. As far as developments going forward, I think after there was quite a bit of success in 2020, expanding access of the right to vote, making vote by mail more accessible, removing some of the signature and notary and other requirements, and generally promoting more access to the franchise. There was an incredible turnout in a number of different states, and I'll give an example in a moment. I think now we are seeing the cyclical nature of voter suppression, which is that there's already pushback from some states to try to re-limit the right to vote. The example that comes to mind is Georgia, which recently passed a law that imposed a number of different restrictions. on people's ability to vote after we saw a tremendous turnout in the 2020 election. We filed a lawsuit just yesterday to challenge that law. Then to go back to the state-federal dynamic, we also have HR 1, which is a law making its way through Congress that would vastly expand the right to vote. So when we're thinking through what's coming next, I think that those are the two things that we need to keep an eye on. One, states responding to increased turnout and expanded access to the franchise by restricting that access again. Two, whether Congress will now pass a law that's going to set a much higher floor on voting rights and voter protection. And it remains to be seen, I think, in the coming year, how those two events, if the federal law passes, will collide or not collide, and how the courts will treat and interpret those two things. So I think going forward, we are going to see, unfortunately, additional restrictions on the right to vote. I do, however, think that vote by mail will be something that is hopefully here to stay, that people will demand access to voting by mail in a number of different states. I think that's too popular to turn back the clock on. And I think we're going to keep seeing questions of the composition of the electorate, like rights restoration after a conviction. And of course, Jim certainly is more active in this than I have ever been, but it's a redistricting year. And so we're going to see a lot of attention focused on how district lines will be drawn going forward. So that's a very brief summary of the background to voting rights, what we just saw in the previous election, and what I think we can expect to see in the next few months. And I would be more than happy to answer any questions that anybody has about the work that we do or what we plan to do going forward.
Thank you. That was a fantastic overview. There are so many things there that I think I want to come back to. Mr. Blacksher, sort of the same to you. Tell us a little bit about your career and the work that you do, and sort of what you saw over the last year, especially, I think, in Alabama. We definitely want to talk about what it's looking like and what it looked like, this election looked like in this state.
Great. Thanks, Samuel. And first of all, I want to congratulate all you undergraduate students who are taking a more aggressive interest in voting rights. That's encouraging to me and to all of us who've been involved in voting rights, which was a pretty lonely group 40, 50 years ago, but now it's all the rage. But I think that what I'd like to do in my short few minutes is to point out how you and your generation are sort of an inflection point in American voting history, in American history. The 2020 election has brought out in the open the radical polarization of politics in the whole country, a polarization that is basically racial in its nature, that has always been with us here in Alabama and the rest of the South. And you really can't understand why it's that way now unless you're able to put it into an historical context. I think it's important to remember that democracy in the world is a relatively new phenomenon. It has existed anywhere in the world less than 2 centuries. Mass electorates did not appear anywhere in the world until roughly the Andrew Jackson election in 1828 in the United States. When all white men were universally enfranchised, did not appear in Europe until the second half of the 19th century. And there's a reason for that. You think about why democracy was always a threat to government throughout the world, and I'm talking now particularly about the European world that we've inherited here. And that's because the people who owned wealth, which was primarily property, primarily real property, and they saw government and still see government as an institution that's designed primarily to protect the wealth that they have and to help them to grow that wealth. And therefore, the masses of people who are not wealthy, who are not stakeholders, who are not property owners, if you will, are seen as not legitimate members of the people who should control government, and people to be feared by those who do hold wealth. So in 1787, when the founders gave us the Constitution of the United States, there is no right to vote in that Constitution, and still isn't today, left up to the states. And the Constitution that we have was written in order, as I said, to protect the ability of people who own wealth to continue to protect it and to acquire more wealth. So what happens is that democracy takes hold, particularly in the first part of the 19th century, leading up to the famous Jackson presidency. And we finally see most of the United States allowing all white males to vote, even if they're not property owners. So what are the wealthy going to do? What are the wealthy going to do in the face of this growing movement towards mass democracy in order to prevent democratic processes from transferring wealth from the people who own property to those who do not? And the primary way of distributing wealth is through taxation and the spending of government for services for those who do not have the ability to get it themselves, whether it's, and of course, even in the early 19th century, there was no public education. We're talking about that not even existing there. So what we have in Alabama, for example, we have an 1819 Constitution with statehood that enfranchises all white males, but of course explicitly denies the franchise to free blacks. There were very few blacks, but there were free blacks in Alabama, especially in the area I come from in Mobile. Then you have the Civil War and Reconstruction. And what happens in Reconstruction is that the national government, the federal government, the Congress controlled by what we call radical Republicans, in order to deal with the sudden the emancipation of the entire slave population, they enact the 13th, the 14th, and the 15th Amendments to the Constitution, ending slavery in the 13th Amendment, 14th Amendment establishing all persons born and naturalized in the United States as citizens, 15th Amendment prohibiting the discrimination against voters on the basis of race, denying the right to vote or abridging the right to vote on the basis of race. Well, that was because in the 14th Amendment, 13th and 14th Amendment were not considered enough power to enfranchise blacks. The irony is, and most of us in Alabama don't realize, that because of military reconstruction during most of the 1860s, the military required all of the Confederate states, the former Confederate states, to enact new constitutions that enfranchised black males. And the radical Republicans in Congress thought that would be good enough to enfranchise blacks everywhere, and that the 14th Amendment, with all of its provisions about the rights and privileges of citizenship as United States citizens and so forth, would be enough to provide suffrage to all African Americans in the United States. And it turns out that they had to backfill on the 14th Amendment and confess that it would not enfranchise blacks because it was the northern states who did not favor black suffrage at that time. So there's the irony of that. Then we get to the turn of the century, the turn of the 20th century. Between Reconstruction and basically 1900, we had the Democratic Party in the South as the party of white supremacy. In 1874 in Alabama, the conservative Democrats won all of the statewide elections and regained power and immediately enacted a new constitution that had to deal with the problem of black suffrage. Fearing the federal interference in the 15th Amendment, they did not put anything explicitly disfranchising blacks in the 1875 Constitution. So what happened is that the people who owned most of the wealth in the second half of the 19th century in Alabama, like many places in the United States, were wealthy landowners, were planters in the Black Belt of Alabama, where all the former slaves still resided. And during that period between Reconstruction and the turn of the 20th century, white landowners in the Black Belt controlled the Alabama legislature by capturing the votes of their black populations. Their black populations were counted to give them seats controlling the legislature, but they voted, they used fraudulent methods and violence to vote, to cast black votes to promote the interests of the wealthy white planters and their allies in the industrial areas of Birmingham. Well, the white counties, who did not have enough revenue, for example, for their public schools because of restrictions in the 1875 Constitution, were furious. They wanted more freedom to raise taxes, to provide public services and so forth. And there was a revolt in the 1890s, and there was a threat that poor whites and blacks would get together and somehow form a coalition that was strong enough to overcome the power of the conservative white supremacist Democrats. And so as a result, in 1901, Alabama passed a constitution that was explicitly designed to disfranchise blacks and poor whites. The poll tax in particular was powerful enough to disfranchise 2 or 3 times as many whites as blacks, but almost all blacks were disfranchised. So that situation continued until the Voting Rights Act of 1965 was enacted. For over half a century, African Americans in the South and in Alabama could not vote. So what happens in 1965, I'm losing track of the centuries here. The Voting Rights Act passes. Lyndon Johnson says, well, there goes the South. The Alabama Democratic Party had been the party of white supremacy for over 100 years. When I first started voting in Alabama in the early 1960s, the ballot that I marked had the emblem of the Democratic Party, which is a rooster, and the inscription on it was white supremacy for the right. So white supremacy was on the ballot in the state of Alabama when I started voting. And the Alabama Democrats did not take white supremacy off the ballot until 1965. And they were forced to do that. At that point, we reach a change, because for a century, the Democratic Party had been the party of white supremacy, the party of whites. Now, it was the Republican Party who stepped in. And then the famous Southern strategy that was implemented by President Nixon in the 1970s, over the years, it became, the Democratic Party became identified as the party of civil rights. The Republican Party became identified as the party of whites. And as a result, gradually, and I say in Alabama, it was more gradual than in other southern states for the unique reason that George Wallace refused to switch to the Republican Party. And he stayed in office until, what was it? Was it 1983, 1984? I'm losing track of the years a little bit. But eventually, even in Alabama, the Republican Party gained control of all the statewide offices. Hold on, let me try this. Yeah, my speech was so enthralling that I froze for a minute there. Yeah, okay, so now the Southern strategy has succeeded full bore in the South. And today we have absolutely no African Americans elected to any statewide office in the state of Alabama. Many states, southern states, have that situation. And Alabama's political culture has been exported to the rest of the United States, where it always, I suppose, lay dormant anyway. After all, the United States is the only modern democracy in the world that was founded on the institution of slavery itself. So we have a unique legacy. Now, what's happened after the Obama election, serving 2 terms, the whole country has become aware that white supremacy, when I say white supremacy, I'm not talking about an attitude necessarily of hatefulness and spitefulness. I'm talking about white supremacy has always meant in the South political influence by blacks. It's important. White supremacy means that government must be controlled by whites. So what you had in Georgia in this last election was an electorate that had only 52% of the registered voters in Georgia were whites, non-Hispanic whites. People of color were close to being the majority. And thanks to people like Stacey Abrams and all their movement, they were able to mobilize coalitions with many whites and succeed in that election. Here in Alabama, non-Hispanic whites are still 70% of the registered voters. And the only African Americans who serve in the Alabama legislature are elected for majority black constituencies. Now, what that means for you, coming of age voters, getting ready to get involved in the political process, is to understand what the stakes are. I personally don't fully understand, but appreciate that there are many white people in Alabama and elsewhere who are frightened about the idea that their country is no longer controlled by white majorities. But that eventuality is certainly coming. And there has to be a way to deal with it that does not end up in everybody, each side demonizing the other. There has to be a way forward that involves honesty, civil discussion, political compromise, some give and take. But to the extent that it turns into a battle where one side keeps winning until the other side is able to come back and win again, it's just going to be perpetual warfare until this bump, till this issue that has dominated American political culture for 2 centuries is not dealt with forthrightly, the issue of white supremacy. I'll stop with that.
Thank you so much. I think you just mentioned the recent bill introduced in the election in Georgia. Ms. Ebenstein, could you maybe talk about that bill that was introduced in Georgia, that fight that's been going on there, why that bill was introduced, and how, if that bill, if we're going to see similar things in other states, and what those fights might look like based on what we just saw in Georgia.
There we go. I'll just go through some of the specific provisions in that bill. And again, keep in mind that a slight shift in how elections are administered can make the difference for individuals being able to cast their ballot or not, or having their ballot invalidated once they do cast it. There were, I think, 6 main provisions of this bill that are problematic. The first is that prior to this bill, Georgia had mobile voting units. They could shift the location of I'm actually not sure if it was a polling place or a ballot collection facility, but they had these mobile units that under the new bill can only be available in future elections if there's a declaration of emergency by the governor. So that retracted one of the accessibility points that was available in 2020 when the turnout was higher and the electorate more diverse than it had been in the past. The other another requirement was a strict ID requirement that people, I believe it's either have a driver's license number, a state ID number, or photocopy and send in other forms of ID with their vote by mail ballot. You know, I think it's hard for some people to imagine how difficult it can be for people to satisfy this ID requirement, but obviously not everybody has a driver's license or can meet strict ID requirements, even if they're eligible to vote. There is also, as part of that ID requirement, it restricted the amount of time you have to request a vote by mail ballot. There's restrictions on drop boxes. So a widely successful available technique in administering elections this past election was to allow people to return their vote by mail ballots into these drop boxes. I believe in Georgia, it was there was video surveillance or whatever you want to call it of these drop boxes. The new law says that the drop boxes have to be in early voting sites, such as a local registrar's office, which means that the return of the ballots and the availability of drop boxes is limited to when those offices are open. And, you know, we all know from work schedules, student schedules, or both, which I'm sure a lot of you have, you can't always make it to cast your ballot or to return your ballot between, let's say, the hours of 9 to 5 or normal office hours. There was a reduction in the number of early voting days available for runoff elections, with only 1 week of early voting, and that runoff elections need to occur within, I believe it's 28 days of election day. There was a provision that invalidated out of precinct ballots, which means if I'm supposed to go to precinct A, I make a mistake and I vote in precinct B. In the past, they could still count the votes on my ballot for offices that I was qualified to vote for. This law says, nope, throw out the whole ballot. So even if I cast votes for president, Congress, and governor, and I was qualified to do that, just not to vote for my local city council seat in the district where I cast my ballot. Now they throw out all of those votes, the ones that are qualified and the ones that aren't. And then the final provision that's problematic that we challenged was the food and water ban. That's the one that's been really getting a lot of media attention because it's just, in my view, ridiculous and inexcusable. The new law says that you can't offer people online waiting to cast their ballot food and water while they're waiting. That's just outrageous. I mean, we saw hours-long lines, particularly long lines in primarily Black and Hispanic neighborhoods, and a provision that prohibits people from giving their neighbors, strangers, friends water, really in any circumstance, but certainly when they're waiting to exercise a constitutional right and may not be able to do so without help, just to get through the hours-long wait. That's just inexcusable. So those are the primary, the most problematic provisions that we saw in Georgia. And the challenge to those provisions were four main things. First, that they were intentionally discriminatory, that the legislator has a long history of racial discrimination, which Jim just outlined in fantastic detail, specific to Alabama, but of course, Georgia shares a lot of that history. And in recent history, there's been a number of voter suppression efforts there. So we believe this bill was passed intentionally to discriminate against Black voters. There's a Voting Rights Act claim to say that the effect of the bill, whatever the intent was, will be to disenfranchise Black voters. There's a claim, a constitutional claim that we refer to in shorthand as an Anderson verdict claim. It says that there is an undue burden on the right to vote. So basically, states cannot burden the right to vote without a good reason for doing so. And the amount of burden that's placed on the right to vote is balanced by a court against the necessity for passing a particular law. And if there is no necessity or if there is no rationality behind a law, but it burdens the right to vote, it can be declared unconstitutional. And then the final basis for challenge is the First Amendment that has to do with just the water and food provision. But that's a lot of detail just to say that, again, these details are important. Something like a mobile unit, a mobile voting unit, can make the difference for folks who are not mobile themselves to be able to cast their ballot when there's no way that they could get to the polling place. So those tweaks at the margins can really have a dire impact on elections.
Thank you. I think, and maybe both of you will. Allie, do you have a question you'd like to butt in?
I do have a question. So, Ms. Ebenstein, you touched on how current legislative acts are working to suppress the vote. But I'm curious to know a little bit more about how the post-2020 census redistricting will look like in regarding the right to vote. What should we be looking out for? How can we best advocate for fairly apportioned districts? And I'd love to hear from both of you, if Mr. Blacksher, you know specifically about Alabama, how that will look.
I would feel foolish answering that question when the expert is remotely sitting right next to me. So I think maybe Jim is better placed to answer that than I am.
Yeah, the 2020 census data won't be available till sometime in September, perhaps. And the 2022 elections are going to be close on its heels. It's going to be a rush. And the legislatures who are responsible for redrawing congressional state legislative districts are going to have to go into special session more than likely. Bills will be rushed through. There will be little time. There will be little time for for legal challenges before the elections will actually be held. There may be some legal challenges that extend beyond the elections, who knows? But it's become more and more difficult over the years to challenge redistricting in court. And the federal courts now are more and more unfriendly, shall I say, towards the claims of denial of equal protection, of unfairness, of discrimination against racial minorities and so forth in the redistricting process. But with respect to Alabama, I do have something to say. I do have a message that I would like to get out far and wide. Alabama is one of the states, like North Carolina, that has in its own state constitution a requirement that when House and Senate districts are redrawn, they are simply apportioned among the counties, that no counties are to be split among districts. Many of you may not know, but Alabama was the state that was in the US Supreme Court, that the US Supreme Court used to invent the principle of one person, one vote. Only at that time, it was called one man, one vote. In 1964 case was Reynolds versus Sims. And when the Alabama Attorney General went to the Supreme Court, they told the court, we can't draw districts that have numerical equality without violating our own state constitution, which says you can't split a county among districts. And in Reynolds versus Sims, the court wrote that the Equal Protection Clause of the Constitution contains in it a principle that requires equal population among districts to the extent practicable, substantial equal population. But they said to Alabama, your state constitution, which requires avoiding the splitting counties, is still in force to the extent that it can be observed without unnecessarily increasing population disparities. In fact, we know from later Supreme Court decisions that House and Senate districts and state legislatures can have population disparities as much as plus or minus 5% with no questions asked. It's presumed that that automatically satisfies the Equal Protection Clause of the 14th Amendment. But when you start enforcing constraints like don't split counties, it makes it harder for the legislators to draw the districts they want, to put the voters they want in their own districts for party reasons or for incumbency reasons or for whatever. And in fact, here in Alabama, for decades, we worked to increase the number of seats that African Americans would have an opportunity to fill. And in doing that, even more counties were split in order to reach majority Black voting age populations. So now we've reached the point where as I said, the only African Americans in the Alabama legislature are in majority Black districts. And because of the successful Southern strategy, all but two of the Democrats in the Alabama legislature are Black. We have one white Democrat in the House, one white Democrat in the Senate. Both are elected, by the way, in majority Black districts. So to assist in gerrymandering these districts to improve the Republicans' chances in the post-2010 census, they split even more counties. And in order to justify doing that, they said, well, we're going to restrict the allowable deviation, population deviation, to plus or minus 1%. Okay, and you can see that that makes it even more difficult to avoid splitting counties. Supreme Court said in Alabama Legislative Black Caucus versus Alabama, the case that we went to the Supreme Court in last, 2016, they said you don't have to be that strict with population deviations. And we drew some of the districts, but the challenge in post-2020 census redistricting in Alabama is going to be forcing the state legislature to obey the state's own constitution. Do not split counties if you don't have to. The Supreme Court's even said you can have deviations as large as 16% for the sake of avoiding a county split. But what I'm trying to say is, if we're trying to avoid gerrymandering, we've got to keep in mind that every plan that's drawn to redistrict a legislative district, whether it's a congressional district or city council, is going to be gerrymandered, because every plan has winners and losers. It benefits some and it doesn't, and always on purpose. And the only question is how, there is no strict standard of what is fair when it comes to districting. You can't, the Supreme Court said, what was it, 2 years ago, Julie? I forget, it was the North Carolina case. They said, partisan gerrymandering is a non-justiciable issue. Federal courts can't even hear a constitutional claim that districts are being gerrymandered on a partisan basis. So that's left with racial gerrymandering. And racial gerrymandering is a losing end game in itself. What we need to get back to is establishing some standards that, to the extent possible, make it more difficult for the people who are drawing the districts to gerrymander. And that's where the county boundaries come in, and municipal boundaries count too. Because I'm going on beyond what I need to, but I think this is important for people who think about redistricting to realize there are countries who don't have districted elections. It depends on what you want your representation, the people who sit in the legislature, to represent. Do you want them to represent parties? Or do you want them to represent geographical locations? In the English system that we inherited, it was the latter. People are elected to represent their local political subdivision, a county, a town, or whatever. And so when you start breaking up, if you want to have a fair districting scheme that's Republican versus Democrat, Democrats are 37% of the electorate in Alabama. If you want them to hold 37% of the seats, you've got to have a statewide, some sort of a proportional representation system that does not use districts. But we still use geographic districts, and those geographic districts are designed to represent political subdivisions, people in your county, your city. And if they're required to do that, I think you can see at the local level how the people who are elected are going to have to be more responsible to the people in their locality, not to whoever the Republican or the Democratic leader of the House or the Senate is. So I could go on about this, but I have preached to the lawyers who represent the legislature, who represent the Attorney General of Alabama, to everybody I possibly can. Force the legislature, when they go in to draw these districts, to observe county boundaries, not to split them. I mean, Tuscaloosa County is just ridiculous the way it's split up among districts, House and Senate, and congressional districts. Terry Sewell's district winds through Tuscaloosa County and goes up a big corridor into Jefferson County, as you know. By the way, Alabama may lose a congressional seat. We may go from 7 to 6 seats after April 30, I think. The Census Bureau is going to let us know what the statewide totals are, so that congressional seats, House seats are apportioned among the states. It's not absolutely certain, but we may end up with 6 districts. That's going to cause a big shakeout. But you can draw congressional districts in Alabama without splitting county boundaries. It's a lot easier. It's a lot easier because you have bigger populations, and so the smaller, the deviations are percentage-wise smaller. And in a case of about 2 or 3 years ago called Tennant versus Jefferson County, West Virginia, the Supreme Court said congressional districts can have deviations of 0.5% or even more for the sake of preserving county boundaries. So county boundaries can be a tool for limiting the ability of legislators to gerrymander congressional districts. Did I answer your question, or did I just give the left-hand one?
Yeah, that's great. It's great to know what it's going to be looking like in Alabama in the next few months. Thank you.
I would just add one issue nationally, which is that we saw in the last few years a couple of states change their state law or state constitution to allow for nonpartisan commissions to undertake the redistricting process instead of the legislature itself. Now, how that'll work in practice remains to be seen, but that's also a provision of HR 1, which would require nonpartisan commissions, independent commissions, to be charged with redistricting. As Jim said, there's still winners and losers. You're still making intentional decisions. But I think at least there's some focus and some effort, some recognition that there needs to be a little bit more, we need more fairness, and that's never going to come about if folks have individual or party interests that are not counterbalanced by some mechanism or process for independence. So that's another issue to keep an eye on as we think through redistricting.
And I would just add, Julie, that independent redistricting commissions are not going to take gerrymandering out of the process.
Right. Yeah.
They're going to be impartial, and they're not going to be independent. And politics is definitely going to play a role, and they always do. I'm trying to remember the name of the scientist who, after the Supreme Court announced one person voted in 1964, said when it comes to, he was talking about academics, he was a political scientist. He says, in academia, there are no nonpartisans, there may be some non-participants. And that principle applies to redistricting. Well, but I won't try to make a case against it.
They would at least require some counterbalancing forces to work together, but I agree with you, they certainly wouldn't take politics or partisanship out of the process completely.
Well, we are quickly running out of time, and I have one last question that I want to make sure I hear from both of you on. It's something I think a lot about as we're approaching this 1 year anniversary of the deaths of John Lewis and C.T. Vivian. That time last year when we saw both of them pass away in quick succession really struck me. I was lucky enough to get to hear from John Lewis a couple of times. I've been lucky enough to meet many of the sort of giants of the civil rights movement. But it sort of struck me, it has stayed with me over the last year, that it seems like my generation, our generation, Generation Z, might be the last generation that gets the chance to really build those relationships with the folks of that generation. And especially as someone who grew up in Alabama, is from Alabama, not just the giants, but also the foot soldiers of that movement are and have been around my whole life. They've been my teachers, they've been grandparents, they're folks I know, but I worry that the impact that they've had on me, that generation has had on me, is not something that folks a whole lot younger than me are going to be able to experience in the same way I have. How do we keep the legacy of that generation alive? How do we keep the legacy of that movement alive? And what can we as college students and as young people do as part of that project? What advice do you have for us in keeping that torch lit?
Well, I think it's encouraging to see the growth of, for example, the Birmingham Civil Rights Institute, the Equal Justice Institute's what do they call the new museum in Montgomery? Pardon? Legacy. The Legacy. And I'm leaving a lot of people on. Tuscaloosa, the University of Alabama has some of this going on, memorializing the role that, in 1962, when George Wallace stood in the front door of Foster Auditorium and was facing off with Vivian Malone and, oh my God, I'm blanking on his name now. God forgive me. Anyway, I remember Vivian Malone because she was from Mobile. But, I think there's some effort underway, for example, to try to make sure that Foster Auditorium is preserved as an historical site. There's so much on the University of Alabama campus. I mean, I know you're going through some renaming right now, am I right? Some re-examination of a lot of stuff. The same is going on at the HBCUs, ASU, Alabama State, Alabama A&M. Alabama State has the Civil Rights Institute that they're trying to develop, and there's a lot of movement. Troy State has the Rosa Parks Museum going in downtown Montgomery, for heaven's sake. Yeah, there's a lot being done, and more needs to be done to memorialize and keep alive the legacy. But I think that actually the Birmingham Civil Rights Institutes, any of you who haven't been there and looked at it and walked through it, you really owe it to yourself and to your next generation, if you will, to familiarize yourself with those important facts that happened right in our living lifetimes.
I would just add and encourage everybody who's joining this program and all college students to act as both mentors and mentees. I think it's important to connect with those who have voted, worked as activists, been activists, devoted themselves to expanding voting rights, led the civil rights effort. I would encourage people to connect with the folks who have experience in this area of work, and then receiving that to act as mentors to others within your generation. So if you've already figured out as a college student how to register and vote, if you're in a new state, pass along that information to as many people as possible. I think there's always a way to connect with people who were on the front lines of this battle and have been for a long time, and in any way possible to pass that along. My 4-month-old daughter was gifted a onesie that says "Good Trouble" from a voting rights colleague of mine. So I certainly hope that for generations to come, John Lewis's legacy will remain active and of course memorable. But we all do need to carry that torch and to make sure that the wisdom given to us is passed along.
I just corrected it. The name I was missing was James Alexander Hood. He was from Gadsden. I'm sorry.
Well, I want to thank you both so much for spending this time with us, for giving us inspiration and knowledge as we move forward. Thank you so much. And thank you to everyone who joined us tonight. We truly appreciate it. And I certainly really enjoyed this program. Thank you.
Thank you again for having us.